So what exactly is self-preferencing and how does it limit competition? What does it mean for consumers?
All right. Self-preferencing is one of 9 case studies that I looked at in an independent working paper with Robin Chabon and Anna Quarry. It's basically a behavior where market operators, so digital platforms that are both owned by a company that they also operate within, they give self-preferential treatment to their products over others. So when you're searching for something, even though another product might be much cheaper, might have much higher ratings, right? In theory, it's of higher quality. No matter what, your product compared to that of the parent company are depressed in search. I feel I'm not doing it succinctly, but I can give you an example that'll bring it to life more effectively. If you go online to order your groceries with something like No Frills owned by Loblaw, as I do, no matter what, if you choose, if you're searching for cookies, which I always am, those President's Choice cookies are going to come up first. Now that is an example of a private label brand that's being self-preferenced on a platform. And what that means for competitors is that when they're participating as third parties in that marketplace, they are subject to the parent company that's setting the terms of competition in that marketplace and creating an inability for them to show up high in search rankings. So we should talk about it and think about whether our laws care about this. Is this an anti-competitive behavior?
So, I mean, can you give me an example of how that hurts consumers, though? Because, I mean, I think a lot of consumers know that the PC brand is a Loblaw's brand, right? But there are a lot of other examples where they might not necessarily know that. And I think one of those times is often on Amazon.
Absolutely. So, I mean, it hurts consumers. There's a huge blindness for consumers, right? The expectation that consumers have may not be aligned with the experience they have when they're searching. So at the very least, one of the things we've put forward is, self-preferencing could be a form of deceptive advertising. Maybe it should be labeled. Maybe it should say owned by Amazon, right? Not everything that's owned by Amazon is labeled as an Amazon basic product per se. But again, this is happening. It's not just the largest technology firms that's engaging in this behavior, which is why it's so important to look at both the behavior and the behavior in Canada. The Bay is an online third-party marketplace. Canadian Tire, Marks, which was formerly Marks Work Warehouse. Those are Canadian examples where consumers don't know that it's happening necessarily, and competitors are having competition stifled.
Now, Keldon, I want to turn to you for your perspective on competition law and how it applies in the digital sphere. Is there a gap in our competition law that makes it easier for digital platforms to sort of use market dominance to their advantage?
Yeah, I think that problems in digital markets are really an extension of the problems in Canadian competition law in more traditional markets. I'll give an example from before. We were talking about mergers, where our laws really allow competitors to buy up their rivals. In digital markets, we talk a lot about small companies growing very quickly to become competitive challenges. And our current law with respect to digital markets would say, if the company is still small, well, that's probably not going to be a big deal, and it's going to allow the company to purchase that small player that could very quickly become a competitor. So again, I would say the problems we have with traditional markets, a weak merger law is magnified in digital markets where competitors can emerge quite quickly, but not appear to be a threat sort of today.
Now, Vas, we've got about a minute, but one of the big stories in the U.S. on sort of digital market dominance behavior was with some app stores that were prohibiting competitors from listing apps on their store. Would Canadian law have any applicability to things like that?
We've taken no cases in Canada on this activity of gatekeeping, and yet we're seeing other regulators, competition regulators, caring deeply about this, both in terms of the apps that can come forward in the App Store, both in terms of the 30% commission that developers tend to have to pay. This tends to be a norm. And also in terms of the gatekeeping ability to force somebody to use the proprietary payment system. So does Canadian competition law care about this right now? We haven't seen any cases come forward, but this is the right question to be asking. Can our competition law even contemplate this? And is the evidentiary burden too high for us to consider a case?
We've got to go to commercial break, but we'll be right back.